Okay, can everybody still hear me?
Yes, we can.
Okay, wonderful.
Yes, sir.
Well, first of all, let me just begin by introducing myself. I'll bring up my video very shortly, but let me just begin by introducing myself. My name is Samuel Wilkinson, and I shall be your lecturer for the next 3 sessions of Trust Administration Stage 1. And I know you've done some introductory work already, and I hope you found that enlightening. I'll be responsible for the next 4 units, I think it is 6 through 9, over the course of the next 3 sessions. And I'll do a little bit of housekeeping very shortly as soon as I've done my register, so that you can have an idea of where and how we're going to do this. Let me just say right at the beginning that I usually encourage students to be as interactive as possible. If, as we go through these discussions, you have any questions, issues, life experiences, anything you'd like to share with with myself and your colleagues, I'm sure it'll be helpful for someone somewhere in their profession. So feel free. Um, let's keep it as informal as we can. I don't have a problem with that. That's we learn a lot of stuff outside of the context of the textbook, so it will be my pleasure. But first of all, let's do some introductions. Let me leave my cell number in case you need to give me a call or send me a text. Everyone, my cell number is 565-9551. All right, 565-9551. And my email address, if you need to send me an email for any reason, is S as in Samuel, J as in Jack, H as in Henry, Wilkinson, Wilkinson, at hotmail.com. Feel free to send me a text, call, send me an email whenever you think you need to. I have no problem. I usually try to get back within 24 hours. If you send me any information or inquiries and I don't get back in 24 hours, just please send me a follow up and say, what about your 24-hour thing? And I will certainly be getting back to you as quickly as I can. Yeah. If you have a question that is not directly connected to the units that we're talking about, maybe you have a concern about something you did previously in some of the other units or some other issue of that kind during these sessions, feel free to raise them. I shall answer them as best as I can. Okay? The idea is to try to maximize the time we have together in terms of your trust administration experience. Uh, just a little background. I've been around the lecturing world for a long time. Um, I've been with BIF since forever. Um, Taught at the University of the Bahamas and all kinds of other places. So I've seen a few things in the lecture world. I've also been in private banking for half of my career, so including trust, compliance, senior management, whatever the deal was. So I've seen some interesting things in my lifetime: Brazilian banks, Filipino banks, Canadian, French Canadian banks. So it's been quite a whirlwind. All right, so feel free if you have any questions or inquiries, directly or indirectly related to blah, 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 feel free to raise them at any time. Okay, let's do the register first of all. Let's see who is here. When I call your name, can you please just say whether you're here? And if you are here, just introduce yourself. Tell me who you are, stuff like that, and why you're doing this course, anything like that. Okay. All right. Let's start with looks like Christeria Ambrista. Are you here, Christeria or Chriseria? Uh, Christeria Ambrista, are you here? Okay. Olivia Ferguson. Olivia? No. Tanisha. Tanisha Knowles. Kendra Jones.
Here.
Okay, Kendra, great. All right, Kendra, can you introduce yourself and tell us some stuff? Tell me some stuff.
My name is Kendra Jones. I work at RBC.
Okay.
What else you said you wanted to know?
What do you do at RBC, Kendra?
I can't disclose.
Oh, okay, okay. And so why are you doing trust administration?
I found some interest in the class and I want to venture into that field.
Okay. Actually, it's a very good field to venture into if you're interested. So try to gather as much as you can. I know that the Institute offers part two to this course. If you can, do that part as well. Get as much information as you can, especially if you're interested in trust. Trust administration has been around for hundreds and hundreds of years, and it's still a very huge line of business, especially for wealthy people. Not so wealthy people as well. You don't have to be wealthy to have a trust. And so it's a very popular tool for what we call succession planning for those persons who have wealth or who have something of value that they'd like to leave to somebody they love or some bodies they love once they pass on from this earth. So it's a very, very interesting and dynamic area. So good luck, Kendra, and welcome aboard.
Thank you.
Okay, Donique, are you there? Donique Major?
Hi, it's Daniqua. It's
Don-
Daniqua. Good morning.
Doniqua. Okay, Doniqua,
Yes.
introduce yourself.
Um, my name is Daniqua.
Okay.
I work at
You work at,
RBC as well.
okay.
I too cannot disclose. And I am taking the course because I just want to expand my knowledge in different areas of the banking sector.
Okay, fantastic. Fantastic. Well, good luck and welcome aboard.
Thank you.
Uh, okay, Monique, are you there? Monique Mitchell? Monique Mitchell? Okay. Dominique Roberts.
Hi, good morning. My name is Dominic Roberts. I also work at RBC and I'm unable to disclose. I'm
Good.
taking the course
Okay.
also to gain knowledge in different areas and aspects of banking.
Sounds good. Sounds good. Welcome aboard.
Thank
And
you.
I hope you guys so far and at the end of this experience um, will be much more enlightened, as I'm sure you will be. I've been telling my students for decades, everything you learn is never a waste of time. Sooner or later, somewhere, it will be of value to you. So, good stuff. All right. Thank you, Dominique. Shanice Roll, are you there?
Hi, yes, I'm here.
Hi, Shanice. Introduce yourself.
Okay, my name is Shanice Rule. I work at Equity Bank and Trust Bahamas Limited, and
Okay.
I am a junior trust administrator.
Okay. Yeah.
So I decided to take this course to get my certifications in the trust field.
Excellent. You're definitely on the right track. I think by the time you've done the double sessions, you'll have a whole lot of information under your belt to work with,
Yes,
and that's the key. Yeah, the more information you have, the better you will do that job, especially in the trust department. And certainly, it'll set the stage for you to one day not be a junior trust officer, but be a senior trust officer, and then move on to even more exciting things. Okay, so
right.
welcome aboard.
Thank you.
Okay, Renee Thompson. Renee? Okay. Interesting name. Chaville Gibson? Cheval? Did I say that correctly, Miss Gibson or Mr. Gibson? No? Okay, so I have run out of names on my list. Is there anybody's name I didn't call? Did I call everybody's name?
Good morning.
Good morning. Who am I speaking with?
This is Olivia Ferguson.
Okay, Olivia, introduce yourself.
Okay, but firstly, Christeria and Bristol is having some internet connection
Okay,
problems. So that's why she's not present currently in the class.
okay, but she's trying to get in.
She's trying to get in at the moment.
Okay, wonderful. All right, we'll wait
Okay.
for her to get in, hopefully very shortly. Can you introduce yourself, Olivia?
Okay, my name is Olivia Ferguson. I work in the commercial banking industry.
Okay,
I used to work at a offshore trust company
yes,
in my earlier years,
okay,
and I just decided to take the course to venture more into it to get a full understanding and in hopes of, I guess, trying something new in my career.
sounds good. Trust, trust, trust information and trust work is always a good idea. It's
Yes, sir.
always a good option to have. And in case you haven't noticed it yet, everyone, you'll discover that a lot of this stuff that you'll be learning in Trust One and hopefully Trust Two is not only stuff that will help you in a particular job or aspiration that you have, but it's a good bit of personal information that you can use, bit of information you can use for personal reasons. So don't forget to take account of that part of the learning process. Because a lot of you, for example, perhaps will go on to do investment advisory, financial advisory services. Who knows what the future will bring? You may want to do some planning for yourselves, family member. You have this information, you can help somebody, you can earn some income, you can be better at what you do. So you're definitely on the right track. Okay, thank you very much, Olivia. Is there anybody else who,
Hi,
okay, who's on?
I'm Tanisha.
Tanisha?
Yes.
Okay, hi, Tanisha. Introduce yourself.
I'm Tanisha Knowles. I work at RBC.
Okay,
Um, I decided to take the course because I found an interest in it and just wanted to expand my knowledge.
okay, expansion sounds good. Um, Wonderful. So welcome aboard, Tanisha. Um, I'm sure you probably won't regret it. It's quite a bit of interesting information. Okay, great. Do I have? Did I call everybody? Did I have everybody? Anybody else? Okay, wonderful. As I said, please, I run an open session. If you have any thoughts, comments, any of that stuff, please feel free to voice them. You can interrupt me at any time. You don't need to wait for an appropriate time to raise a question, tell us a story, gripe about something. That's perfectly fine. Uh, you may want to gripe about something that's not directly related to trust. I encourage you to take the opportunity because maybe your colleagues might be able to offer some feedback. And the point is, let's make it a learning experience wherever we can in this process. Does not have to be always directly trust related. All right. Any questions before I go on? Okay. Well, just a little bit of housekeeping then. For the next three sessions, we have 4 units that we will seek to cover. Today, we'll start with Unit 6, which are the duties and powers of the trustee. You'll see very shortly that duties and powers are not synonymous. They do not mean the same thing in the trust world, even though some people have the notion that they do. Even people in the trust world for some reason, but you'll discover that duties and trust and powers of the trustee are in many cases mutually exclusive. They are not the same. And then next week, we'll seek to cover Unit 7 and 8, which is the trust administration um, in general and the application of the trust concepts. And then in our final unit, Unit 9, we'll seek to cover the role and responsibilities of the trust administrator. Usually, as we'll see, the trust administrator is that person who quote unquote administrates or runs the trust on a day-to-day basis on behalf of the trustee. I'm hoping by now that somebody would have told you in your introductory sessions that trustees might be individuals or entities. Have you been told that?
Yes.
Yeah.
Hmm.
So you don't have to be a company to be a trustee, like a bank or financial institution. Uh, any one of you can actually be a trustee. If you have a sister, for example, who comes to you and say, "Look, if I died prematurely and my children are not able to take care of themselves, I would like to leave everything I have to you as trustee on behalf of my children to make sure that they benefit from whatever assets I have left for their education, their health, and their welfare until they're able to look after themselves." And that can be a verbal agreement between you and your sister or anybody else or your brother, um, or it can be a written document. Um, that is pretty typical in the trust world. What is the written document that we normally use in the trust world to set up a trust? Anybody remembers?
Is that the trustee?
It is the trust deed. It is the Bible of the trust world. If you work in the trust business and there's no trust deed, you have a problem to begin with. Okay? 99.9% of all trust arrangements are written, especially uh, by, by professional trustees. And if there's not a written trust deed, you better get one real quick because you're going to have some problems along the way. Even if you decide to become an individual trustee for some reason, you should still find an attorney, a lawyer somewhere, or somebody who can write a trust deed for you as trustee to make sure that the terms and conditions are clearly spelled out um, in that document. Without that document, if some illegal issue comes up, some beneficiary decides to sue, somebody has a gripe, you can find yourself in some trouble if you don't have that deed to protect you as trustee. So, for example, we have a junior trustee in our group who's looking to become a trust manager one day and all that great stuff and make lots of money and so on. And so she would want to understand right away that in my world, whenever you ask me to do something as a trustee, please produce the trust document because I'm not going to operate without it. It's a very important feature, very important function of the trust administration process. All right, so that's kind of what we'll be looking at over the next three sessions. By the way, does anybody remember what a discretionary trust is from your previous classes? Anybody? Make a guess. What is a discretionary trust? Make up something.
A
Discretionary trust is.
discretionary
Mhm.
is a trust in where the trustee has a discretion as to the payment of income or capital.
Absolutely. Simple as that. Um, the trustee has discretion. The trustee can determine based on their own circumstances and the current circumstances of the beneficiary and the trust at the time, how to pay and manage income and capital. Okay. Now, what is the opposite of a discretionary trust? Anyone? What is the opposite? If it's not a discretionary trust, what is it?
Non-discretionary.
Non-discretionary, absolutely. So These are the ABCs of the trust world. The differences between discretionary and the trustee, and how crucial it is to the management and administration of the trust. These are the ABCs. Anything you might forget along the way and have to refer to, always keep these kinds of things in the back of your mind because they are fundamental to the trust process. And here's why. Uh, if you have a non-discretionary trust, it means you cannot use your opinion, your experience, and your background to make a decision. You must go to a trust document. If it says pay money to the mafia, doesn't matter if you agree or not. You have to pay it. Does everybody follow that?
Yes, sir.
If it has in a trust deed, don't pay money to my third sick child because I hate them for some reason. Doesn't matter how you feel. You cannot say this is wrong. I'm not doing it. You cannot do that as a trustee. If it's a non-discretionary, you must follow the instructions to the T. Okay, students, it's as simple as that. Now, if it's a discretionary trust, then you could determine, how could this settlor have the heart to say that this third child who's handicapped should not be looked after? In my discretion, I'm going to make some of the money available to do that because that's the moral and correct thing to do and godly thing even. And then in your discretion, you can do that. But if you have a non-discretionary trust and you do not act according to that trust, you can be sued as a trustee. And if you found you will then have to pay the legal fees and any other determinations by the court. And who will normally bring this suit about? Generally beneficiaries. So be careful as a trustee. You cannot act helter-skelter. You must know what kind of trust you're dealing with and then behave accordingly. Uh, Trustees are sued every day, so to speak, these days, because beneficiaries, unlike in the past, are much more aware of what's going on. They're looking at the money that is left by their parents and others on their behalf. Everybody wants more. Everybody wants to know who's getting what as beneficiaries. And there's a lot of fighting going on among many beneficiaries in the Bahamas and around the world. Okay, so these are very important things for trustees to think about going forward. All right, another background question, the A's and B's of trusts. What are the three primary components of establishing a trust? Who are the three main participants of a trust? Anybody remembers?
Is that the settlor, the beneficiary, and the trustee?
Absolutely. All right, the settlor, the beneficiary, and the trustee. Any trust that is not constituted with those things clearly defined, we have a problem. Any trust that is constituted means established without the assets being transferred from the settlor to the trustee legally is going to probably determine to be a sham trust. And if any beneficiary brings a suit against the trustee is likely to lose that suit. Okay? So these things are long before we get to unit 6 through 9. These things are fundamental to understanding trusts. These things are fundamental to making sure you administer a trust properly. Okay? There should be no question at this stage of the game that a settlor is the person who establishes the trust with a trustee, whether it's institutional, meaning entity, professional trustee, or individual, that the settlor agrees to transfer his or her assets to the trust legally, which means that once the assets are transferred, the settlor no longer owns those assets. Doesn't matter how they feel afterwards. Okay? They no longer own those assets. They are now sitting in trust for the beneficiary, for the benefit of beneficiaries. And of course, every trust must have somebody to benefit from it. Otherwise, it is not deemed to be a fully constituted trust. And those persons or entities are called beneficiaries. And they must be clearly defined in that trust instrument. Okay, so here we go, the ABCs of trust administration. No matter how sophisticated your work gets, you must always remember those fundamentals in terms of doing your job, because it's always the little things that will drown you. Like, I felt sorry for the beneficiary, that's why I gave the money. And then the courts will say, but you didn't have the discretion to do it. The trust instrument clearly said, don't do it. And then you said, you burst into tears and said, well, I'm sorry, I just didn't see that child not be taken care of. And the courts will say, I'm sorry too. Here's our decision. You did not follow the trust deed as specified, Mr. Trustee. So now you're liable. Okay? So those are some, like any other job and its requirements. You have to keep those important things in mind. Okay. So I just thought I'd go back in time for a moment, just to remind you of those fundamental things, and how important they are. I've seen, we have cases all too often, every other week somewhere in the world, where some beneficiary is suing the trustee because they feel the trustee did not act appropriately or in accordance with the trustee. So this is not old time stuff. This is very current, even in modern trusteeships. Okay, so keep that in mind. The other thing I want to mention from a housekeeping perspective is the self-assessment tests. I'm sure you know by now at the end of each unit you have a self-assessment test of some kind. I encourage you at the end of each reading to go ahead or lecture to go ahead and do those. What I will do for the next two sessions, for example, next week, we will do the self-assessments for unit 6, 7, and 8. And here's how that's going to work. After today's lecture, next week when we get together, we'll do the self-assessment for today's class, and then at the end of the lecture next week, we'll do the self-assessment for 7 and 8. So if what you can do is go ahead and do all three self-assessments and be ready for those. And then in our final session in week 3, we'll do the self-assessment at the end of our lecture for unit 9. So that's our plan for the next 3 sessions. And if you have any questions or concerns about any of that stuff along the way, please feel free to raise them. Any questions so far? Okay. A little bit more housekeeping. At the end of your units, there are 2 other things that you may have been seeing in the past and even in the units that we'll be discussing. Those 2 things are related to the Trustee Act. Does anybody remember the dates for the Trustee Act of the Bahamas? Anybody? Trustee Act, which year or years? We have the original act year and then
1998.
yeah, the original is 1998, and then we had 1 or 2 amendments. Anybody remember those amendments? Yes.
Was one in 2011.
Yes. Were there any after 2011? No. So Trustee Act 1998 was the original trustee establishment of the Trustee Act, and then we had an amendment, yes, in 2011. For you, I encourage you, you may not necessarily read them all if you have started looking at that at all, but you certainly want to know what the basic tenets and components of the Trustee Act and the amendments are. I don't suggest you try to read it all within this semester that you're actually doing this work, but I do encourage you to look at the table of contents and see what kind of reference material is sitting in the Trustee Act and the amendments. So at least you have an idea of what's sitting in there. And if you need to make a particular reference, you can go ahead and do that. Okay? So please make a note of that. The other thing you'll find at the end of your units is what we call some case references. I believe your previous lectures may have alluded to the importance of cases, but let me just say this: you're not here to be attorneys. You're here to be trustees or to learn the rules and natures of trusteeship, which is not to become a lawyer. The reason why trustees familiarize themselves with cases is so that they can have some idea what's going on in the legal world in areas that affect their work as trustees. So I encourage you to review the cases as far as you can. You don't necessarily get bogged down in all the legal mumbo jumbo, sorry, but to certainly look at what certain cases represent, especially if they come up more than once in a discussion, see what the core issues are in the case, and then see what rulings were made as a result of a particular case, so that at least you have an idea. It's very possible that you may be tested on a couple of cases that will be highlighted, no doubt. Um, and even if you're not tested directly on cases, you may be required to refer to a couple of them in certain answers with regards to your examination. So you don't have to walk around with all the cases in your head like a law student. That's not the idea here. But you do want to have an idea of what certain case references are about. And certainly in my units where those cases come up, if it's not indicated what those cases represent, we'll have a little short discussion so that at least you're aware. In the event that you need to make a reference to those cases, you can do that without stress. Okay? That's the idea. All right, so keep those two things in mind. And as you go forward with regards to the study of each of these units. Again, some of these cases go on because they're Old English cases. Some are modern cases. You're not here to pass a law exam. You're just here to understand how a particular case refers to a particular trust concept. And so I encourage you to keep it in that context so you don't stress yourselves unnecessarily. Okay? The other thing before I get into our lecture for today is um, I have one or two interesting videos I like to show, use either before or after the lecture to reinforce some of the things that we're going to be discussing, certainly in my units. Beginning today, actually, I found one that I think might be especially good as an opening for the duties and powers of the trustee, which is the source of our lecture for today. So what I would like to do is if I can find a way to share this screen to start with this particular video, and then we get into our lecture. Okay. And like I said, please feel free to raise any questions that you might have at any time. Okay. Okay, let's see, share screen. Just give me a second. I just need to get Miguel to put me online. Give me 1 second.
Hey, Wilkinson, how you doing? Sorry, I own like 3 calls. Everything okay?
Yeah, I'm just trying to share my screen. It says host is not allowing to share screen.
Okay, sorry, Wilkie. Yes, talk to me.
I just need to share my screen.
Oh, sorry about that. Sorry about that. Okay, let me do it right now. My
Okay.
apologies.
Thanks.
All right.
Okay, great. Let's see. Share screen. Can you guys see this video?
Yes, I can see it.
Okay, wonderful, wonderful. Doggone it, that actually worked. Sorry, sometimes these things don't always work. Okay, great. Here we go. So this chap is going to give us some introductory comments on powers and duties of trustees to get us ready for our lecture. So let's take a few moments and see what he has to say.
So with that in mind, let's get started by thinking about what exactly are powers and duties. So what do we mean by duties and powers in the context of a trust? Well, whereas a duty is something that has to be exercised by the trustee, in other words, they have to do it, a power is something that can be exercised by the trustee. In other words,
Can you guys hear that? Hear him? Hello? Can you hear him?
I can hear him.
Yeah, from
Okay.
my end, it's real loud.
Okay.
Yeah, we
Very good.
can.
Wonderful.
Right.
Okay, let's go. So notice everybody right off the top the difference between duties and powers, and we'll be discussing this a little bit later in our lecture. But the key thing to remember is that a trustee duty is a duty that must. Must means the trustee has no discretion. They must do it. They must do it. The powers of a trustee, on the other hand, means that they can be exercised, but not necessarily will be. Okay, very fundamental to this particular lecture. All right, let's go.
they have the option to not necessarily have to exercise that particular power. Now, there are a couple of caveats associated with this. So, whereas a trustee does have to exercise a duty, the way in which they do so is sort of up to them. And so they are given a lot of discretion in that sense. On the other hand, whereas powers are optional, for want of a better word, in cases of discretionary trusts, a power may have to be exercised by the trustee. In the words, that option is taken away. So that's definitely something to look out for. Now, this idea of discretion that we've talked about does also have its own legal meaning, so we'll try and explore that. In particular, the recent case of Pitt and Holt, which is really important, tells us that trustees do still have to act in good faith when exercising their discretion. They also have to act responsibly, reasonably, based on the facts. So this means looking at things like the type of trust that they're involved with. If it's something like pensions, then they should maybe only make low risk investments, whereas if they're trying to make as much money as possible, then the trustees are probably more inclined to make high risk investments. And they often have to act on the advice of experts in particular areas. And that might be things like scientists or people like that, but more often than not, it's going to be thinking about things like accountants to consider which is the option which gives them the best tax benefits for their particular type of trust, and also lawyers for exercising some of those duties and powers as well. So
Now, notice, folks, I mentioned not too long ago the issue of cases. And if you notice right away in this particular discussion, there's a reference to a case called Pitt versus Holt, 2013, very recent case relative to older cases. And in this case, there was a lot of discussion about the responsibilities of the trustee. And as you can see, those responsibilities are very significant. And we'll see in our discussions of the fiduciary responsibilities of the trustee and some other areas where trustees are expected to do quite a few things, and understandably so, because they're acting in the interest of their beneficiaries. And the beneficiaries are only interested in what they're entitled to, and the trustees only interested, at least should only be interested, in making sure that they get their entitlements. Therefore, as a trustee, individual or professional, good faith is crucial. Responsible and reasonableness is crucial. Using the facts, not opinions and feelings, are crucial. And getting good advice is crucial. Okay, as we will see throughout our discussions. For those of you who are curious, I encourage you to take a look at Pitt versus Holt and have a look at the essence of the case and the rulings of the case. And you should find that these kinds of expressions, such as good faith, responsibility, and reasonableness, etc., will come up in that discussion. That's kind of the point. You don't have to remember all the details of the case, just the key issues pertaining to your particular studies. Okay? Did everybody hear all of that?
Yes, sir.
Okay, just making sure, because sometimes these bloody machines do their own thing. Okay, here we go.
Some important points there when it comes to exercising discretion. And this is really important because while trustees don't have to give reasons for their decisions, the courts are only going to step in when the trustees have acted in bad faith. In other words, where they've not met that criteria that we just talked about in the case of Pitt and Holt. And that comes from the case of Klug and Klug from 1918. And while they don't have to give reasons for their decisions, if they do decide to give reasons for their decisions, then that is something that can be looked at by the court when considering whether the trustees did act in bad faith or not. And that
very important point here, and I'm just making them as they come up, in case you want to make a note of it somewhere. This thing about trustee decisions, okay? It's important to know that when a trustee acts, a trustee is expected to be acting in a fiduciary or good faith manner, and therefore legally, trustees are not required to give reasons for decisions that they make. In law, even if a beneficiary seeks to sue a trustee, the trustee can say, hey, I don't have to give a reason why I made that decision. I made it as a trustee and I made it in good faith. Now, that is generally accepted in the world of trust unless a beneficiary brings a case that a trustee acted in bad faith. And bad faith means that the trustee has done something legally or morally wrong in terms of that decision. And if the court feels that the beneficiary's case is correct, that the trustee did, in fact, act in bad faith, then the trustee will be expected to give the reasons for the decisions so that the courts can make a final determination. If the trustee continues to refuse to give a reason, then the courts will find the trustee in contempt of court and more than likely rule in favor of the beneficiaries. Okay? And as you can see, we have cases that you can refer to for each of these situations. Beloved Wilkes Charity is a very important case in Klug and Klug in terms of where the trustees have to give reasons and under what conditions the courts will interfere with the decision of the trustee. And it's important at least to be able to refer to those cases, even if you don't remember all the details of the cases, that they are connected to these very important decisions by the trustee. Okay? All right.
it comes from Klug and Klug as well from 1918. What about the cases of bad advice? Well, in previous case law, mistakes which were based on bad advice, say for example, you want to find out which type of trust is going to give you the best tax advantage, and an accountant gives you bad advice that the trustee then acts upon. Well, in that type of situation, the trustee has essentially taken into account irrelevant considerations, and so that mistake could essentially be undone by the courts, and that comes from the case of Re Hastings Bass from 1975. However, this all changed thanks to the previous case that we mentioned of Pitt and Holt from 2013. And this says that a decision that's based on bad advice will still stand if the trustees acted with appropriate care and diligence. In other words, if the trustees have acted in good faith, then it's not going to be for the courts to get involved and basically fix that mistake for the trustees. So this creates a potential problem for beneficiaries who are trying to find a remedy But there is perhaps an indirect remedy against the person who gave the advice. So you might be thinking about something like professional negligence against the accountant in the example we described, or there may be a direct remedy based on mistake, but that's a little bit harder to prove and so not necessarily ideal. So on the one hand, in this decision in Pitt and Holt, the courts have sort of upheld the decisions of trustees and allowed them greater discretion, but it's taken away some of the remedies available to a beneficiary if a mistake has been made.
Now, students, let me just say this. This is very important because many cases in the past and in recent history have suffered because of these concepts in law. Let me just remind you that yes, the trustee's job is to administer who gets paid what based on the settlor's settlement with the trust. That still remains the fundamental duty of the trustee, but trustees are often confronted very, very often by the lawyers of beneficiaries who are seeking to find out what's going on in the trust and whether they're entitled to more than they are actually getting, etc. Okay? So this question about whether the trustee acted in good faith or in bad faith is a very, very popular contentious issue in law for trustees. Beneficiaries are constantly seeking to accuse trustees of acting in bad faith, hoping that they can get more than they currently get in terms of the settlement. Right? So trustees have to be aware and at all times that they're acting quote unquote in good faith. Because usually if they're acting in good faith under Pitt and Holt, the courts won't bother them. The courts will say if somebody tries to sue, go out and find another remedy. As far as we can see, they acted in good faith, and that's fine. Now, if the beneficiaries can prove with their attorneys that the trustee acted in bad faith, then the courts might step in and say, okay, we agree that you acted in bad faith, and therefore we rule in favor of the beneficiaries against the trustee. Mr. Trustee, you have to pay the legal fees and any other remedies that this case requires. Case closed. Okay. So trustees have, and again, sometimes these cases run into the thousands of dollars or millions of dollars, depending on the size of the trust. Remember, a trustee can be as small as $50,000 or less, or as big as billions of dollars, depending on the situation. For example, in the case of Microsoft, we already know that Bill Gates and his wife have set up several trusts for many different reasons. And many of those trusts will contain billions of dollars to do all kinds of interesting things even after they're dead. Okay? Some good, some bad, and some ugly, by the way, in case you're not aware. But the point is, this is the nature of the trust. And so trustees are always aware, or must always be aware, that beneficiaries, whoever they might be, are constantly looking for remedies against the trust, especially if they feel they should be getting more of something. Okay? In the case of Hastings versus Bass, when you get to look at that case, you will see that basically, if the trustees act on the advice of a professional, such as a lawyer or an accountant or some other professional, architect, whoever the case might be in the case of the trust issue at hand, and they acted on that advice and things go wrong, the beneficiary might sue, but the courts will rule in favor of the trustees because they will say the trustee acted on the advice of the professional and therefore they acted in good faith. You might ask, well, what do we do in a case like that as a beneficiary? Well, what do you do? What you have to do then, since the court protects the trustee under Hastings versus Bass, the beneficiary will then perhaps have to seek a remedy against the professional who gave the advice and take them to court separately to see if they can get a claim against the professional that they claim gave bad advice in their professional capacity. Okay? I know that's a mouthful perhaps, but I just want you to be aware, even at this early stage, and you'll see more of this discussion as you do the next level course, um, to add to your repertoire of information to do your jobs better. But just kind of introduce you to the kinds of things that are out there in the real world of trusts. It's not just a matter of sending money to some beneficiary somewhere every 6 months or a year. There are a lot of other things going on, which many of you who go on to your professional trustee lives will discover. Okay?
So let's get into the core of the duties and the powers as well. So we'll start with the duties. These are sort of the most powerful things, the things that the trustees actually have to do. And the first basic thing that they have to do is actually provide information to the beneficiaries. That can be things like documentation that relates to the trust or relates to the property. Basically, any relevant documentation or information has to be provided. That comes from Londonderry Settlement from 1965. Secondly, the trustees have to act impartially between the different beneficiaries, maybe different relationships between the beneficiaries. It might be like a 60-40 relationship between the beneficiaries, but they still should act appropriately in that regard. This often comes up in the cases of property, in particular thinking about life tenants and remaindermen.
Now, students, let me ask you something at this stage immediately. What do you think we mean by trustees must act impartially? What do you think we mean? Anyone? Trustees must act impartially between beneficiaries. What does that mean, you think?
I would say like not biased.
Yeah, don't be biased. Exactly. Okay. In other words, if you are a trustee, you cannot, should not have a favorite beneficiary for no reason. And if you do have a favorite beneficiary for some reason, you still have to act fairly and unbiasedly. You cannot treat beneficiaries like your favorite child. Like some people have their favorite child or their favorite children that they love. And then they have some of their children that they don't particularly love as much, or whatever the case might be, for whatever reason. Uh, that's human nature, quote unquote. But trustees, they may have their favorite beneficiaries too. But as far as the duty of the trustee is concerned, see, the duty. Remember, duty means what? Must do, must do. As far as the duty is concerned, they cannot act more favorably towards one beneficiary over another. So if a trustee has a beneficiary who constantly nags them and piss them off and harass them, even though they get on their nerves, they can't say, well, in my discretion, I'm going to treat the other beneficiary better because I hate that one. You can't do that, even though you may wish to do it. Because if you discover doing it as trustee, you will be deemed to be acting partially, and therefore violating this requirement of the trustee. Okay? The other thing I want, it's a good point, don't be biased. Okay? We shouldn't have favorite children either. We shouldn't have favorite boyfriends and girlfriends. We shouldn't have favorite, but we do. That's just the way things are. But in the world of trust, we need to be able to draw the line on how we act on what we favor or don't favor. Because as trustees, we must be impartial, full stop, between beneficiaries. Okay. The other question I have for you before we go on: who are life tenants and who are remainder men? You should have come across these two concepts by now. Who are life tenants and who are remainder men? Somebody take a stab at it. Anybody? Who are life tenants in the trust?
The owner of the owner.
Absolutely. Life tenants are those persons who will benefit from the trust until they die. In other words, if a husband or wife dies and leaves a spouse in the house, they're entitled to stay in that house until they die, if they wish. Amount of money every month, they're entitled as a life tenant to be paid that money every month until they die. That's what life tenant means. Once they die, whoever are referred to as the remainder men, they're the ones who get what is left. So if the trust has $10 million in it, After the life tenant benefits are paid for their lives, if 5 million is left, then the other 5 million will go to the remainder men. That's why we call them remainder men, because whatever remains will go to that person or those persons only after satisfying the requirements of the life tenant. Very important issue for trustees. All right, something for you guys to keep in mind. All right, let's go.
And just to give you a little bit of context there, a life tenant is someone who can essentially use a property for all of their life, and the remainderman is the person who gets the property after the life tenant does pass away. And so when you think about that, they have to think about whether, for example, to sell the property. Now, if that's done while the life tenant is alive, then that obviously benefits the life tenant, but it may not be beneficial for the remainderman. And so the trustee in that situation has to try and balance the two sides together, consider whether they should sell the property, and if they do so, how much the life tenant should get, how much the remainderman should get as well. The main duty comes from Section 1.1 of the Trustee Act 2000. This is really talking about a duty of care. And essentially what it's talking about here is that the trustee basically has to act with such care and skill in the circumstances, having regard to things like special knowledge or experience that they may have, either as a trustee or perhaps as someone who has a legal background, for example. And that's kind of the core of the duty that came in the year 2000, because under the previous law, it was mostly based around 19th and early 20th century case law that was simply outdated. And so I've basically put Section 1.1 of the 2000 Act there so that you have a good idea about what the new duty of care is for trustees. So where does this duty of care actually apply to in the context of being a trustee? Well, we've got there, so investments and compounding. Compounding just means increasing the value of the property or investments, acquiring land, appointments such as other trustees, for example, reversions where the property returns back to the settlor, the person who created the trust in the first place, valuations, audits, insurance, all that type of thing is where the duty of care will apply. Section 1.1 of the...
Bear in mind that when we talk about duty and care as a trustee, it means that all those different activities that the trustee is required to carry on behalf of beneficiaries that we just saw previously, in every one of them, the trustee cannot be careless, they cannot be personal, they cannot be unprofessional. They must exercise the duty of care in carrying them all out on behalf of the beneficiaries. After all, that's why trustees are paid to do their jobs. Okay? They cannot treat it casually or cavalier. Otherwise, beneficiaries are always watching. And if they detect that you are treating any of those activities that you're responsible for as trustee with less than the proper duty of care, they will have their lawyers on your tail like a pack of wolves. Happens all the time. Okay? All right.
Trustee Act 2000 is backed up by sections 3, 4, and 5. Section 3 basically just says a trustee can make any investment that he is allowed to under the trust, so gives them a bit of discretion there. Section 4 says the criteria for investments is based on suitability and diversity. In other words, not putting all of your eggs into one basket, but spreading out the risk as much as they certainly should do so. And suitability kind of comes back to the idea that we mentioned earlier about whether it's sort of the trust where you should make a low risk investment, or maybe it's something where you should be making a high risk investment. Section 5 talks about considering and obtaining advice, which is pretty similar to what we've already talked about in the context of Pitt and Holt. So definitely something that's now represented in statute as well. Let's move on to some of the powers though. And it's important to say that because these have a lesser status, in other words, like we said right at the start, these are essentially optional. They can actually be excluded by the trust instrument. So the first one that we're talking about here, which is the power of maintenance under Section 31 of the 1925 Act, it would certainly be possible that the power of maintenance is excluded by the trust instrument, and that would be allowed even though it sort of essentially goes against what is in the statute.
Now, let me say this, students. I don't know if in your previous lectures you've been advised that the current Trustee Act of the Bahamas 1998 and its amendment of 2011 are actually based on the English Trustee Act, the original English Trustee Act of 1925. Hopefully, you've been introduced to that already. Certainly, our Trustee Act of 1998 is just what we call a modern Trustee Act to update the old English Trustee Act, which they still refer to in the United Kingdom, and which we still refer to as well, since we are a common law country with our Trustee Act based on the UK Trustee Act. Okay, that's an important thing to know, just for general information, that all of this stuff that you refer to in the Trustee Act of 1998 and its amendment is fundamentally based on the Trustee Act UK 1925. And in some cases where we might have a Bahamian trust, where the beneficiary might be in the UK or UK citizen, if there's an action in the courts, it could easily be raised as part of the 1925 Act, even though we have our modern Trustee Act of 1998, which will also come into reference somewhere in some legal argument. So it's important to at least be aware of these things. Don't lose any sleep over them yet. Impact most of you at this stage of the game, but it's nice to be aware that these things are out there and how they relate to the world of trusts. Okay? All right. I notice also that these powers, we are told, are not necessarily powers that have to be part of the trust instrument, which raises a very interesting point, because we now know, at least at this stage of the game, that if a trustee has a duty, that duty must more than likely be included in the trust instrument, but powers are not required to be included in the trust instrument. They may be, but they don't have to be. Duties, on the other hand, must be included as part of the trust instrument, at least any well-written trust instrument, which, by the way, some of them are not well-written, which is a whole other issue outside the scope of this particular session. But they're not all well-written, even though they may look well-written. Okay.
So you mentioned maintenance there. What do we actually mean by this? Well, this is money that's paid out from the trust to a parent or guardian of a child beneficiary, and that's for their maintenance, education, or general benefit. And so it might be something like a school trip or something like that, just to pay for their schooling or music lessons, and maintenance can be paid out of the trust to a parent or guardian to support that. Meanwhile, under Section 32, we also have the trustees have the power to advance capital money to any beneficiary for that person's benefit. And so we're no longer dealing with just simply with child beneficiaries in this situation. This may be an adult beneficiary who, for example, is wanting to start a business, and so they want a lump sum of money paid out of the trust instead of having to go out and maybe get a business loan or something like that. So that power exists under Section 32, although, as we say, anyone with a prior life interest does have to consent as per Section 32(1)(c). Meanwhile, benefit is given a broad interpretation, so it doesn't necessarily just have to be a financial benefit, it can just be of a general benefit to that person. Maybe that the person wants to go on a gap year on a round the world trip, and if that's considered to be of benefit to them, then that will generally be allowed. Section 8 of the 2000 Act offers trustees the power to buy land, which is relatively broad and relaxed.
By the way, if you were to check our Trustee Act of 1998, even though the wording might be a little different, you'll find that these investment references and the powers of the trustee are also indicated in specific sections and subsections of the modern Trustee Act of the Bahamas. So while you're having coffee later today, you might find yourself a little curious, as I suggest you should, and go and have a look at one or two of those things to see if they really exist in the Trustee Act. And if you don't see them, then you may want to make a note of that for next week and say, wait a minute, what kind of trustee act is that? I didn't say anything about any of those things. And that should cause for an interesting discussion. Okay? But you should find that stuff even in our trustee act, because a lot of what we did in our trustee act 1998, remember, is based on the old English trustee act. Question? Question? Sorry, somebody had a question?
I do.
Okay.
Can a beneficiary request a copy of the trust instrument?
They could request it, but whether or not they will get it still remains a fight between trustees and beneficiaries. And that's an excellent question. As a matter of fact, they just had a case last year that was running for some time of a Bahamas trust where they were trying to get the trustee in the Bahamas to disclose certain information to beneficiaries. And of course, under the Modern Trustee Act of the Bahamas, we were saying that certain trust documents like trust instruments and minutes of the trustee meetings and why trustees make decisions is privileged information for trustees, and beneficiaries are not entitled to receive that information. And so the broad answer is no. Uh, However, some beneficiaries are persistent depending on what their goals and objectives are, and they might pursue the issue to try and get the information. And since it is impossible to tell what decisions court will make at the end of the day, given the information and the persistence of somebody making a claim, it is possible that one or two exceptions could be made, but generally speaking, the answer is no, not for that kind of information.
Well, how
Excellent question.
in some cases, then how does the beneficiary know that they are getting what they are entitled to?
Well, if they don't believe the instructions that the trustee has given from the trust instrument, and they actually want to see it in print, they can bring action against the trustee, and the courts might allow them to see the section of the trustee act that pertains to their benefit. You follow?
Hmm.
They will not
Another
get a copy of
question.
the entire document, because that would mean they would know what all the other beneficiaries are getting. And that's never the objective.
Okay, I know that we have when they talk about sui juris, how, say if I'm a beneficiary,
Mhm.
how do I get to the point where it is sui juris if I don't know who the other beneficiaries are? Is it in the trust instrument?
Yeah, the
How
problem,
how would a beneficiary know who all the other beneficiaries are?
it is not intended that the beneficiaries know who each the others are. That is not a requirement of the trustee to, to say to each beneficiary, these are all the beneficiaries. Some beneficiaries don't even know they're beneficiaries yet. You follow? So in some cases, beneficiaries are advised, let's say, after the settlor dies or under some other circumstance, they may be advised that they're now beneficiaries. But there are many beneficiaries like remaindermen and charities and others who do not even yet know that they are beneficiaries. And they won't know until some contingency occurs, like the settlor dies or something else occurs based on the rules of the settlement. So generally speaking, unless beneficiaries come to know each other, trustees are not going to contact the beneficiaries. These are the other beneficiaries, not necessarily. And this is what each beneficiary is getting. Definitely not that, because that will always start a war. You follow? Now, sometimes
Understood.
beneficiaries, yeah, because people say, how come they're getting more than I'm getting? I'm the other's child. I'm the whatever it is. Then a big fight breaks out. Now, sometimes beneficiaries get to know each other. They start talking. You follow? And they start telling each other, well, last year I got 100,000 or a million. Then the other, a million? And I only got 10,000. What the hell? Then war breaks out. And they come to the trustee and said, what's going on? How come? And the trustee said, well, I can't discuss that with you. In my discretion, that's what was done. Or in my non-discretion, the CEPLA said, do that. And I did exactly what the trustee did, or I did what my discretion allowed me to do. Some beneficiaries don't accept it, and that's why they sue. And that's why it goes to court. Then the court will make a decision as to what should be disclosed and to what extent. Okay? So that is an excellent question that is constantly uh, under duress, and cases keep coming with regards to who should be disclosed as beneficiaries, to what extent should beneficiaries get information, and so on. Okay? So it's an ongoing battle for sure. Okay? And it has been going on forever. And chances are it's not going to end anytime soon. Okay? Because trustees, again, there's certain information that's considered privileged. A trustee does not have to disclose, but beneficiaries, for whatever reason, whether they're talking to other beneficiaries, they find out something from somewhere else. Um, they have a relationship with one of the trustees and they get information on the inside during one of their dinner dates or whatever the case might be. Then a war starts. Okay? And it's ongoing. So it's a great question. And it's a great question for any trustee to keep in mind.
Do that. And meanwhile, there is also another power which is in relation to delegation, and the trustee can delegate decisions except for those which relate to the distribution of assets. In other words, which beneficiaries get which money or property, the payment of fees from income or capital of the trust. In other words, if fees, certain lawyers' fees have to be paid, or like we were talking about with experts, if they have to pay the experts, and that has to come out of the trust money, then that is a decision that should be made by the trustee. Appointment of new trustees also has to be obviously made by existing trustees rather than a delegated person. And any further sub-delegation is also not really possible. It's something only the trustee can actually delegate.
And these are four other important points, and you'll see them again about trustee delegation in the terms of the decision making. Like many other aspects of lives, we can delegate certain responsibilities, but we're still responsible for the outcome. So I might be the trustee and I have a legal department, a head of legal, a head of accounting, whatever, and I might delegate a responsibility for disbursements to the accounts department or legal decisions to the legal department. But at the end of the day, as the trustee is still liable for the outcome, whether it's good or bad. All right. So decisions may be delegated, but the trustee is still responsible. However, there are certain decisions that cannot be delegated, and this is what is listed here, such as how assets are going to be distributed, how payment of income and capital will be made, appointing new trustees, and so on. They cannot be delegated. The trustee must do those, him or herself. Okay?
Finally, it's really important just to quickly mention about the possibility of excluding liability, because this is really powerful and something that a lot of trust instruments will now include. Because the trust instrument itself can exclude a great deal of liability for loss or damage which is actually caused by the trustee. In other words, even though throughout this whole lecture we talked about the various powers and duties that the trustee has to abide by, if the trustee basically messes up and causes a significant amount of loss or damage, then under the case of Armitage and Nurse from 1998, as long as that liability is excluded within the trust instrument itself, then they will avoid all liability for doing so. And so this is quite a popular topic for essay questions, as I'll mention in conclusion. However, for now, all we need to really say is that while this covers sort of negligence and loss and damages, if there is a loss which is caused by fraud, then that is not going to be something which can be excluded for in terms of liability.
Now, let me just say this as an extension. Under Armitage versus Nurse, that case basically, if you have a look at it, that case basically says, hey, if the trustee is covered under liability, a liability clause in the trust instrument, and he operates in good faith within that clause, and something goes wrong, then the trustee is protected. However, if the trustee commits fraud against the trust, which many trustees have done in the past, by the way, they're not all honest because they're called trustees. They're all expected to be honest, but they're not all honest. And sometimes some trustees commit fraud against the trust for their own financial and other benefit. If they are found to be acting fraudulently, then no liability clause in the trust instrument will protect them. If a suit is brought against them or they're discovered, they will be ruled to be acting fraudulently and therefore they will not be secured by any liability clause. Period. Okay? Very important point.
The powers and duties of trustees is likely to come up as part of a
Okay, so there you have it. Just trying to get rid of this guy now. Okay, can everybody still hear me?
Yes.
Yes.
Okay, wonderful.
Yes.
All right, so hopefully that little 10-minute excerpt and that little discussion kind of opened the door a little bit um, for our discussions today on the duties and powers of the trustees. So now we can actually get into our lecture by extension with regards to these duties and powers in terms of understanding the differences between the two and what they are and how to administer them, and certainly how to apply the fiduciary functions of the trustee. Remember, the fiduciary function is basically the trustee acting in good care. Everything the trustee does on behalf of the trust must be for the benefit of beneficiaries only. The trustee is not supposed to benefit personally from any of his activities. If he's found to be fraudulent or benefiting personally, then he's acting in bad faith. Okay? He's no longer acting in his fiduciary responsibility. Okay? So, with that in mind, then let's get right into the trustee duties. I think I've yapped enough for the moment. Kenisha, are you there?
Yes.
Okay, Kenisha, why don't you open the reading session for me, beginning with trustee duties. Let's see what they have to say.
Trustees' duties. As mentioned previously, trustees are fiduciaries, one who acts on behalf of another with regard to a particular matter. And as fiduciaries, trustees are in a position of trust and confidence in which they have a duty of loyalty to the beneficiaries of their respective trusts. Bristol and West Building Society versus Matthew, 1996. A trustee has a standard of care as established in Spike versus Gaunt, 1883. That as a general rule, a trustee sufficiently discharges his duty if he takes in managing trust affairs all those precautions which an ordinary prudent man of business would take in managing affairs of his own. A higher standard of care is required for a professional trustee. Trustees' duties relate primarily to the management of trust assets and the distribution of such assets in accordance with the provisions of the trust instrument. Generally, these trusts are owned to the beneficiaries of the trust, and any breach of those duties or an improper or negligent performance of such duties may result in the commencement of a breach of trust action by the beneficiaries or some liability on the part of the trustee. Trustees' duties may be divided into three broad categories of duties. Management duties, example, investment, management, and distribution of trust property reasonably, fairly, prudently, and equitably. 2. Administrative duties. Trustees must know and carry out the terms of the trust. 3. Duties of propriety. Trustees must not act dishonestly and inappropriately, must treat all beneficiaries fairly, and communicate with beneficiaries in a professional and timely manner.
Yes.
One of the primary duties of a trustee in relation to the trust administration is to act in good faith and in the best interest of the trust. Additionally, trustees must not place themselves in a position where the duty conflicts with their personal interests. Should a trustee's duty with conflict with his personal interest, he will be liable to account to the beneficiaries for any profits made by him as a result of this conflict. 3 verses 4, 1896. It does not matter how honestly a trustee acted or that he has invested considerable time or effort in administration of a trust, if he is found to have acted in conflict of his duties to the beneficiaries of the trust. There may, however, be instances where the trust instrument expressly provides that the fiduciary duty shall not apply in a specific circumstance. If the trustee is placed by the settlor in a position where his duty and interest conflict, then different considerations will apply, such as under Neville versus National Westminster Bank, 1990. In addition to the foregoing duties, trustees must become acquainted and familiarize themselves with the terms of the trust, administer the trust in accordance with its ability, treat all beneficiaries fairly and impartially, give account of the trust funds and trust investments to the beneficiaries, invest trust property in a timely and authorized manner, protect and preserve trust property, keep the beneficiaries informed in accordance with the trust instrument and the law, not make a personal profit unless authorized to do so in the trust instrument, the beneficiaries, if sujers, or the court. Not delegate the performance of their duties or exercise powers unless authorized to do so by the trust instrument, and act prudently in the administration of the trust.
Thank you very much, Kenisha. Really, believe it or not, you have already said a mouthful.
Yes.
So let's just go back for a moment before we go forward and remind ourselves that the difference between a trustee's duty and his power is that one is a must and the other one is a may. Big difference. Even in the story of our daily lives, there's some things that we may do, which is a power, and there's some things we must do, which is a must. Okay? If you are a parent, you must look after your children. If you are not a parent of the child, you may look after the child. See, big difference between the two, and it's kind of like that for trustees, and that's why trustees must know what they must do as a duty and what they may do with the powers that they have as trustee. Very important stuff. Notice in each key point that was mentioned by Kenisha in terms of the trustee duties, there's a reference to a particular case. Again, I encourage you to go and just look at the case. Obviously, you're not going to remember them all, but for those who do remember them all for references, fine. If you don't remember them all, don't jump off the bridge. It's not the end of the world. You try to relate as many of the cases in the context to the particular conversation. Okay, that's really the point. And the reason, of course, you may or may not know by now we have these cases is because when they get to the court of law, lawyers start looking at past and previous cases to make their case for their clients, to justify their behavior, whether the client is the trustee or the beneficiary or someone else. And these case studies and these case histories, which we call common law cases, stuff that have happened before and rulings that have been made before in similar situations, often come up. That's why we make reference to them in the discussion of trustees. All right. Also, keep in mind the 3 main duties of the trustee among all the other duties is the management side of things, the duty to invest and distribute trust money, property reasonably, fairly, see, fairly, prudently, meaning wisely, and equitably, meaning fairly again. People, beneficiaries should get what they're entitled to under non-discretionary trust. And if it's a discretionary trust, you still have to be fair, even though you get to say John will get 10,000 and Mary will get 15,000. Um, Even in your discretion, you must act fairly. You cannot take it personally and have any favorites, as we saw. Okay, and And these words are very strong words on the management duties for trustees in terms of what must be done. Okay? Fairly, prudently, equitably, reasonably, very powerful words. Not all trustees practice them, unfortunately. Okay? There are some trustees who act in bad faith, unfortunately. Then we have the administrative duties of the trustee, which he or she must carry out and carry out the terms of the trust. If the trust tells you to shoot the dog when it turns 3, you must arrange to shoot the dog. What happens after that, we'll see. But if you don't shoot the dog, according to the trust instrument, then you will be found liable for not following the trust deed. That's how strong a conviction and responsibility you have when you have a written trust deed in front of you, especially if it offers you no discretion. Okay? It tells you this is a non-discretionary trust, do this, this, and this, you must do it. It didn't ask you whether you agree with it, right? It didn't give you any discretion. If you have a discretionary trust, then you may exercise your own personal discretion based on your experience and your background and your fairness and so on. But even in acting in discretion, with discretion, you must also be reasonable, fair, wise, which is prudent, and equitable, which is fair. Okay? And then finally, the duty of propriety. Okay? Trustees must not act dishonestly. See? Not act dishonestly. I don't care which beneficiary is your friend, your girlfriend, your boyfriend, your bestest cousin, doesn't matter. You must not act dishonestly and inappropriately. You must treat all beneficiaries fairly. Not some, not 97%. All, 100%. Period. And communicate with beneficiaries in a what? Professional and timely manner. So they're supposed to get a payment on the 23rd of March and you're late, you should contact them and apologize for being late and letting them know when the payment will come. Professional and timely. If they're supposed to get it on the 23rd of March, you don't wait until 6 months later. Oh, by the way, we forgot. Here's your money, bloody beneficiary, or something. You cannot do that. And the reason why we have it here is because some trustees behave that way, believe it or not. Professional ones do. Just like professional mechanics act slick, so they fix your car and didn't fix it. Charge you more than they should charge, even though they're professionals. That's the whole point. Okay? That's why we have these discussions. We have this academic discussion about what the requirements are, so that persons like yourself, when you get into this world, or if you agree to be a trustee, or whatever the case might be, you will know what is required of you. Okay? I cannot stress any more than we already talked about in our video and in reading by Kenisha in the second page. One of the primary duties, see, primary first duties of the trustee is to act in good faith. Act in good faith. The reason why we keep stressing this with fiduciary responsibility is because not all trustees act in good faith. Some of them try to get some of the money for themselves. Some of them make deals using their position as trustee to get property and other benefits for themselves. That is a no. If your cousin or your friend or your sister says, I need this money to take care of my children, you can arrange to get a fee if you agree with the person who you're acting as trustee for. But other than your fee that you agree to, you shouldn't be trying to get more. Like, man, she dead, I can keep some for myself and my children, or whatever the case might be. You're not supposed to do that. That is not good faith. And so whether you're a professional trustee or individual trustee, you have to act in good faith for the benefit of the beneficiaries. Okay? That relative left the money with you to look after their children or their affairs. Doesn't matter whether you agree with what needs to be done. You have to follow through with their requirements. Certainly what is the fair and correct thing to do without any personal benefit. The only personal benefit you should get as trustee is what you agree to with the settlor or the individual leaving you as trustee. Okay? Now, if you didn't agree on a payment and you feel this is a bunch of work as trustee, I need to be paid something, feel free to go to the court. Let the court make a ruling on whether you should be paid and how much. But you as trustee should not make that decision on your own if that was not agreed to with the settlor and person leaving you with the trust assets or leaving the assets in your trust. Okay? And notice this laundry list of trustee duties. These 10 things are not exhaustive, but they are crucial. Okay? And notice each one of them have critical consequences and major requirements. Okay? Every trustee must become acquainted and familiar with the terms of the trust. Believe it or not, there are a lot of trustees out there who are just acting from memory. Since they've been sending money to beneficiaries every year for the last 10 years. Now we remember. So yes, I think it's 7,000 or 100, whatever it is, and nobody wants to go back and check the instrument anymore for a long time. And then you discover when somebody brings an action that really you were really not acting in accordance with the instrument. So don't forget the instrument is there. Be familiar with it as trustee. Okay? Notice number 2, administer the trust in accordance with the terms of the trust, not your terms, not your feelings, not who you like in terms of the trust. Treat all beneficiaries, we said that again, keeps coming up, fairly and impartially. Any trustee, personal or professional. Invest trust property. Don't just leave the money sitting on a bank account that's not paying any interest. Are there any banks in Nassau that are not paying interest these days, anyone? Are there any banks in Nassau that are not paying interest today? Am I the only one who's aware of this situation?
Yeah, I wasn't aware of it, of anything.
Or you thought all banks were paying interest currently on your savings account?
Not necessarily, but I assumed some were, but not all.
Indeed, some are, but not all these days. And as a matter of fact, some banks, depending on the amount of a CD or savings account you open, the interest rate that they're paying is 0.000, which is equal to what? Zero.
Nothing, zero.
Yeah, absolutely. And then others, they have a little something else going on. There's for your CD, your little 10,000 CD that you managed to take forever to save. When you open it, they pay you 0.001, which is how much? 1253757. Is that a lot?
Nope.
No, that's not even a full 1% yet.
Exactly.
So you could have a little 10,000 CD, and at the end of the year, when you go to see what interest is paid, they will see $3.77 or something. You say, what the hell? What happened? They say, we didn't tell you when you opened the CD. The interest rate is only 0.001232526 Okay, but not all institutions are paying such low rates. And if you're a trustee, you shouldn't put the trust assets on that account that's paying that low rate, especially if another institution is doing what? Anyone? If one institution is paying 0.001, should you put the trust assets there, the money there, or should you find an institution that's paying more?
Find an institution that's paying more.
Of course, you
Mhm.
find a reputable institution that's paying more. If you put it on that account with the 0.001 and beneficiaries find out, they can sue you and win.
Mhm.
This is how the hell you could put our money on a 0.001 account and right down the road is another bank that's paying 2%. See my point?
Yes, sir.
Yeah. And they will argue and argue successfully. This is what we mean by the trust property must be invested timely and in authorized fashion and properly so that we can maximize the benefit for beneficiaries in terms of the interest earned on cash deposits, CDs, or whatever other investments are made in securities markets even. Okay? So the trustee's job is not just accepting the money and the property and putting it there and waiting to see who gets what. It's much more than that. And when you get into the second part of your trust experience and your trust learning, you'll see more details in terms of how important these responsibilities are. Okay? Number 6, protect and preserve the trust property. So crucial. Trustee students, so crucial. Trustees must always be careful that they preserve and protect the property of the trust. If they've been found to be handling it casually and unprofessionally, they can be sued and be found wanting by the courts. Okay, very serious stuff. Keep beneficiaries informed, very important. Somebody raised a question about if the beneficiaries want to see the deed, can they? And we said yes and no, depending on what they want to see and what part of it and why. But the point is, it doesn't change the fact that beneficiaries should be kept up to date. Beneficiaries should know how much interest is earned on the money. Beneficiaries should know how the investments performed the previous year. Beneficiaries should know these kinds of things. Any other significant information that could impact the benefit of beneficiaries, they should be told. The reason why it's here as a duty, because not a lot of, sometimes trustees do not perform their duties deliberately. They hide information from beneficiaries for one reason or another, not the least of which includes fraudulent trustees, and they feel if they tell beneficiaries, they may find out something. Okay? These are very serious duties. And again, this list is not exhaustive, but it sure covers some of the important things that trustees need to be aware of. You would think that with the information so clearly stipulated, even at this level of study, that every trustee should be acting accordingly, and the truth is they're not. Okay? Remember last year when we had the pandemic, everybody was supposed to be wearing a mask and they were not. And we said people were dying and they still didn't wear it. And so on. And should we wear it? And do we need it? And when do we need it? And I only need. And so all these protocols uh, are out there. And in the case of the trustee, these duties are like protocols. They have to do them. And if they discovered not doing them by any beneficiaries or others, they can be brought to bear. Okay. Number 8, do not make any personal profit being a trustee. Okay, it's almost like stealing from the collection plate. Let me ask you guys something. If you steal from the collection plate, would you go to hell? Anyone?
I think so, yeah.
I would assume so.
Yeah, according to our Bible teaching, certainly when I was a boy,
Mhm.
and certainly now, we know thou should not steal, um, and we should not steal. Uh, but you know, we're not making any excuses for stealing anything. We should not steal, period. But if you steal from the collection plate once and then you say, oh gee, I can't sleep. I thief from the collection plate and all that stuff. And then you seek forgiveness and all that stuff. God will surely forgive you. He's not like the court of law. If you're a trustee and you profit or you steal and it gets to court, they will not forgive you. They will condemn you and charge you. That's how it works. So do not make a personal profit as a trustee unless what? You are authorized to do so where? Not by word of mouth, would somebody tell you, in the instrument by the beneficiaries or the court. What does sui juris mean again? Anyone? That came up earlier, sui juris.
Of sound mind and legal age.
Absolutely, of sound mind and legal age. Okay, so the trustee can only make a profit under 1, 2, 3 conditions. It must be the instrument. It must be authorized by all the beneficiaries, not some, all. Or if you have sound mind and legal age, by the court. All right, simple as that. If you are not making profit under those conditions, you should not be profiting from the trust in any way. You shouldn't be sneaking stuff off like they're not going to just drive this one and license in my name because they're rich. All right, just know for sure that many rich people are worse than poor people when it comes to their stuff. If you take something from a poor person, I might say, anyway, okay. But if you take something from a rich person, they're not always so kind. But under any circumstances, trustees are not allowed to do it, whatever it is. Okay? Number 9, do not delegate performance or duties, etc., unless what? Authorized to do so by the instrument. That's why you need to go to number one. An instrument property that you don't know anything about or you're not familiar with. Okay. And last but not least, act prudently. Prudently means wisely. Comes from a Latin word prudens, prudentis, which means wise. Act prudently, wisely, in good faith, in the administration of the trust. Period. And the expectation is if you do 10 first, you should do the other 9 automatically. Even though sometimes in practice it doesn't happen, people keep trying to get away with stuff. Okay? For one reason or another. All right, thank you, Kenesha. Dominica, are you still there?
Daniqua, yes, I'm here.
Okay, Dominico, why don't you pick it up? The case of Boardman versus Phipps.
Okay. Okay. The case of
Dominico, are you there? I think you're losing.
acquired. Can you hear me? I'm reading.
Yes, we can hear you now.
I'm sorry, I just got back on a short while ago. Can you tell me what paragraph you guys are on our page, please?
Yeah. Page 2, at the bottom, the last paragraph.
No person standing in a fiduciary to account for profit acquired. We're on page 60 in our books, I think it is. So
Okay,
I'm
thank
starting
you.
where it says the case of Boardman versus, okay.
Yes.
All right.
The case of Boardman versus Phipps, 1967, illustrates the importance of trustees not making secret profits from the trust without authorization. No person standing in a fiduciary position when a demand is made upon him by the person to whom he stands in a fiduciary relationship to account for profit acquired, the opportunity and the knowledge, or either resulting from it, is upon any grounds, save that he made profits with the knowledge and assent of the other person. Profiters' fees, re macadam, profits made by him into competition with the business belonging to his trust, IDC versus Cooley. Trustee may not delegate his duties to an agent, third party, or co-trustee unless he is instrument. In order to delegate such duties, the trustee must ensure that there are provisions made in the trust instrument to allow him to appoint agents and delegate tasks for the administration of the trust. In common law, the case of Steele versus Wellcome Custodian Trustees Limited, 1988, confirmed even in law for the delegation of his duties to an agent. However, under the Trustee Act 1998, the trustee must take reasonable steps in the appointment of such agents and in the supervision of the delegated tasks. It is important to note that only in exceptional circumstances may a fiduciary receive remuneration for his time and effort in acting in such capacity. As a general rule, trustees are not allowed to be in relation to the trust unless they are authorized by the trust instrument. Therefore, trustees must ensure that the trust instrument allows them to be remunerated from the trust fund for reasonable expenses, example, out-of-pocket expenses incurred in the administration of the trust. The court does have discretion to allow remuneration or increase a trustee's remuneration. Foster versus Spencer, 1996, and Reduke of Norfolk Settlement Trust, 1982.
Okay, stick a pin in equal. Hold a second. Let me just say this while I remember it in my
Trustee
mind.
Powers.
One second, Daniqua. let me just say,
Okay.
let me just say this. Going back a little, I noticed Taniqua said earlier that the trustee may delegate if he is authorized to delegate by the instrument. However, at the end of the day, the trustee is still responsible for any decisions that are made by whomever he delegates the task to. So you can delegate the job, but not the responsibility. Okay. So, for example, um, if somebody leaves their child with me, I am constructively a trustee for that child until I return the child to them. If I say to somebody else, I'd like to leave this child with you because I have somewhere to go, I have delegated that responsibility, but the responsibility is still mine. If something happens to the child, when the parent returns, they're going to look to me for what went wrong and for any remedy as a result. So just like in a case like that, a trustee may delegate responsibilities to a lawyer, a doctor, an accountant, or whatever other professional, but at the end of the day, the beneficiary will look to the trustee if something goes wrong. Simple as that. Okay, that's the first important thing about a trustee duty. The other important thing about the duty is that there's no legal requirement for the trustee to be paid for his or her work, believe it or not. Okay? It's something, if you're a professional trustee, it is understood now that professional trustees will make arrangements to be paid trustee fees because they have to pay staff in some bank or trust company or financial institution. So therefore, they will make provisions as a professional trustee to be paid in the instrument. Personal trustees similarly have no obligation to be paid unless they agree with the person who's leaving their assets with them that they will get a certain amount of money for their services, and that too should be put in writing. However, anything that is not stipulated in writing, the trustee, personal or professional, cannot just go ahead and pay themselves by saying, oh, this is a bunch of hard work. There's nothing in writing for me to be paid, but I'm going to pay myself. You cannot do that. If you don't have anything in writing and you think you should be paid as a trustee, God forbid, take it to the courts. Okay? Foster and Spencer, Duke of Norfolk, etc., and let the courts decide whether you should be paid or not and how much. All right, keep going, Aniqua.
Okay. Trustee powers. The nature of a trust involves a trustee holding the legal interest in property. The equitable interest in the property is held in the trust for the beneficiary, its lawful owner. A power is where a person owns both the legal and equitable interest in the property. As the absolute owner of the property as he wishes with the property, and may, in his absolute discretion, transfer all or parts of the property to another person. It is important to note that while a trustee may be the legal owner of the trust, he does not have the full powers of a legal owner of property as recognized in law. Trustees may exercise such powers given to them in the trust deed under the Trustee Act or under the general law. Recall that a power is mandatory. In the absence of bad faith, a court will not interfere with a trustee's exercise of his discretion. A trustee will also not be compelled to exercise his fiduciary powers, even though he has a duty to exercise such power. The distinction between a trust and a power placed in a trust was outlined in the case of McPhail versus Dalton, 1971. The powers of a trustee by statute are set out in pars 2, 3, and 4 of the Trustee Act. Some of the main powers are power of investment, power to retain investment, power of sale, power to insure, power to settle claims, power of maintenance, power of advancement, power to concur with others, power to employ agents, and power to apply to the court. Within a trustee's fiduciary power, it is the duty to consider whether to distribute income or capital. Although he is not under a duty to actually distribute Turner versus Turner, 1984. Generally, whether and how he ought to exercise his fiduciary power as stipulated in the case of Mitoy Pensions Trustees Limited versus Evans, 1991.
Thank you very much, Daniqua, for another mouthful of stuff. It looks like every page is PowerPoint with stuff. And obviously, with regards to any discussion about duties and powers of the trustee, everything is packed, everything is relevant, and nothing can be ignored. Notice this laundry list of powers now. We saw the laundry list of duties. Now we have a laundry list of powers. It should suggest to you already uh, the intense responsibilities that trustees have in general, and in particular, if you are professional trustees, you have a higher duty to carry out your job even more effectively than an individual trustee, since individual trustees are usually just person or persons who may not have all the skill sets to have this create this higher expectation. You're still expected to be fiduciary and do all the good stuff of trustees. But if you are a professional trustee, your duty and responsibility and perceptions by courts and beneficiaries are going to be significantly higher. So uh, bear these powers in mind, bear the duties in mind, and make sure as a trustee you understand the difference between the two, such that if even if you get a test question, for example, to, 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 that requires that you you must make sure that you don't cross them over or confuse them, that you know what the duties are and the powers are, and that you can actually list the majority of them in terms of the responsibilities of the trustee. Any cases that you can remember to refer to support your case, you should go forward and do that. Notice the power to compound liabilities and settle claims. So if somebody brings action against the trustee, the trustee the trustee can then go out and get loans on behalf of the trust or pay off any debts that the trust may have. They have the power to maintain. If there's property that needs the building needs a new roof, the yard needs to clean, whatever the case might be, power to maintain, power to advance funds on behalf of beneficiaries as requirement, or just advance money in particular pertaining to the trust. All right, power to make agreements or concurrence with others, employ agents such as investment managers, portfolio managers, accountants, lawyers, and other professionals, and even power to apply to the courts if there's an issue that comes up, an attack against the trust, and the trustee is not clear on what course of action to take. They certainly have the power to apply to the courts for defense or remedy, meaning what is the appropriate action in the court's opinion we should take in this particular matter. That is another area of the trust activity that has been very popular in recent times, in addition to all the actions that beneficiaries have been taking against trusts in terms of suing trusts. Many trusts, when they're being sued by beneficiaries, they may not be clear, their lawyers may not be clear on what course of action to take, and therefore they make the decision to apply to the courts because everybody knows that the court's decision is final. So trustees are well aware that you shouldn't apply to the courts unless you have a serious situation, because once the court makes a ruling, that's it. There's no going back unless you have an appeal. And if the appeal is against you, there's no going back unless you decide to take it to the bloody Privy Council. Okay? But that's where lawyers get paid big bucks by doing business with trustees. So if you're a trustee or you work for a trustee company, you'll see a bunch of lawyers and accountants in particular and portfolio managers who look after the investments of the trust, especially if it's a multi-million or billion-dollar trust, swirling around because there's a lot of money to be made by everybody, especially by these multi-million, billion trust settlements, okay, that go well into the future. All right. Thank you very much, Janique.
I have a question.
Yes.
What would be an example of power of sale? I don't know if I missed it, but I'm not clear.
Power of sale. Let's say the trustee, let's say 5 pieces of property in Albany was settled in the trust. and for some reason the trustee runs out of money, but they still have life tenants to send money to, the wife, disabled children, whatever, to make payments to. But the cash is low for whatever reason. They paid it out for some other stuff. They may decide, take the decision as trustees to sell one of the properties in order to become liquid. So if that is the case, then they have the power to do that, provided they're doing it for the best interest of the trust and the beneficiaries. Whether
Okay,
all the
thank you.
yeah, whether all the beneficiaries will agree is another matter, but they do have the power to do it. What makes that an especially interesting question is that if they exercise that power, that decision might be brought under attack because some beneficiary said, "Why the hell you sold our property? Where's the money?" And you said, "Well, we paid it out otherwise." And said, "To who?" "Well, the other beneficiaries." "Why?" Then a big fight breaks out again, because fights always break out in trusteeships because people are always interested in what's going on with their benefit, so to speak. Even though they didn't work for it, they know that they're the beneficiaries. So they're always fighting for stuff, even though they were just inheriting it. But that's the way it is. And so in the case of a power of sale, what a trustee might do, instead of acting on its own in selling the property, it might then go to where? Apply to the courts and say, "Hey, this is our situation. We have a liquidity problem. We'd like to sell one of the properties in the trust in order to become liquid to satisfy these requirements of distributions that are coming up. And therefore, we'd like to have the court's opinion on this." And then the court will render an opinion. If the court agrees with the trustee, then the trustee goes ahead and sell. Anybody who's dissatisfied as a beneficiary may sue, but the court's ruling is more likely to stand unless there was an error in the court's judgment, which could occur from time to time. Okay, good question. All right, who's Dominique? Are you still there?
Yes.
Okay, Dominique, why don't you pick it up for us? Powers of the trustee. Right under the laundry list.
Page 62,
Mm-hmm.
and I think it would be
It's
the
right, yeah, it's
second
right under the
paragraph.
laundry list. Yeah.
Within a trustee's fiduciary power
Yes.
is the duty to consider whether to distribute income or capital. Although he is not under a duty to actually distribute, Turner versus Turner, 1984. Generally, a trustee must consider whether and how he ought to exercise his fiduciary power, as stipulated in the case of Motti Pensions Trustee Limited versus Evans, 1991. Under trust law, a trustee is mandated to exercise his powers to distribute trust property in accordance with the provisions of the trust instrument. As a corollary of this principle, the discretion to exercise such powers must be done honestly, fairly, and in good faith. The trustee must always keep in mind the goals of the trustee, which are primarily to protect and preserve trust property on behalf of the beneficiaries. Once the trustee acts in good faith in exercising his powers of discretion regarding the distribution of trust property, he will be protected by law, particularly if he has done so according to the terms of the trust instrument and as permitted by law. The Trustee Act of 1998 gives trustees the power to insure themselves and their employees against personal liability and pay insurance premiums from the trust fund, except for breach of trust. Additional powers conferred by sections 14 to 31 of the Trustee Act 1998, unless some contrary provisions exist in the trust instrument. The trustee's power may be restricted or increased by the provisions of the trust instrument. Notwithstanding this fact and the fact that a trustee's power may be expanded by the Trustee Act 1998 and the Trustee Amendment Act 2011, a trustee should ensure that the trust instrument provides sufficiently for his powers so that he is able to discharge his duties and responsibilities efficiently and effectively. More specifically, trustees have the full power of individual beneficial owners absolutely entitled, where they hold real property, and also have the power to borrow trust funds in certain specified circumstances. A trustee's power of discretion may be used in many ways to protect a beneficiary, including the power to withhold income payments to a beneficiary and apply these payments otherwise, particularly where such payments may be claimed by the beneficiary's creditors. A trustee may also make distributions to the beneficiary under certain conditions in order to protect the trust property from being dissipated. Dissipated.
Yeah,
Dis,
sycophant Dominique.
yeah, that.
Yeah, dissipated. Yeah, that may reduce in terms of its liquid position. Whether you realize it or not, you again, you just said a whole ton of things about the power of the trustee, which sometimes even ties up modern active trustees because people get so busy doing the work of distributing money to beneficiaries. Sometimes they don't check to see if they have the right to do it, the conditions to do it, the resources to do it, and so on. This should never be the case, but unfortunately, sometimes it happens more often than it should. So as you can see, after that laundry list, these powers are extended, um, and we're told that, hey, you're a trustee, and you can exercise your power. Make sure the trust instrument gives you the power. If it doesn't give you the power, you can't do it. If you do it, you're gonna run into trouble. Simple as that. Some people, some trustees still do it either out of ignorance or deceit. Either way, if somebody discovers it, you're gonna be in trouble as a trustee. Make sure the instrument gives you the power to do it. If you have a non-discretionary trust, you don't have any power to do anything. You have to do what it tells you to do. If you have a discretionary trust, you have the power to do what is reasonable, right, and proper, and you're required to do that. It's really as simple as that, even though in practice, because people have personal agendas, greed, fraud, and other negative stuff going on, they complicate it perfectly simple process, right? It's like lying. The minute you tell one lie, then you come up with 25 other lies to support the first one. Uh, on the contrary, if you tell the truth, you don't have to think of a bloody thing else. That's it. And folks, that's the truth. Then you can go home and sleep. But once you start lying, then you have to come up with all kinds of stuff. It's like that. When you don't follow the rules of trusteeship, then you have to come up with all kinds of stuff to get out, duck, dodge, lie, hope nobody finds out, all kinds of crazy, make deals, do all kinds of crazy stuff. Okay. And with this discussion is saying, don't do that. Just follow the rules. Of course, some of us never follow the rules, but the discussion is about following the rules, what we ought to do. Okay? So you have these powers, use them, don't abuse them. That's really the point. Use the powers you have as trustees, don't abuse them. Know what your powers are, know what gives you the power, the instrument or otherwise, and then act accordingly. Don't step ultra vires out of your power doing stuff for your own personal benefit, profits, greed, whatever the hell people do stuff for. But we still do it, which is why we have the other remedies called court and prison and
I have,
fine. So
I
on.
have a
Yeah,
question.
question? Mm-hmm.
Yes. Okay. If there's a situation, has there been a situation where a trustee has, say there's three or four multiple trustees,
Right.
and one of the trustees has been removed for whatever reason
Yes.
or has retired from the trust, from being a
Right.
trustee,
Mm-hmm.
and the beneficiaries decide to bring a case to say that that trustee, while they were trustee, has been in breach.
Yes.
Are they still able to bring a case against that person, even though they are no longer the trustee?
Indeed, they are. Okay. Um, that is a very important point, and it has come up many times in the past because for some reason persons believe that if they're no longer a trustee, they're no longer liable. Depending on the nature of the case, they may be liable personally for their behavior, or by extension, the remaining trustees of the trust may be liable for the behavior of that trustee. It's kind of like a partnership. Depending, again, that depends on the nature of the trusteeship. If the trusteeship was a kind of trusteeship partnership where all the trustees were responsible for all the assets, then all the trustees could potentially be liable for the actions of one trustee. However, if it was 3 or 4 individual settlements with separate assets assigned to each trustee, then whoever is in breach of trust, that is the person that could be found liable, even if they're no longer trustee, depending on the nature of the claim, by all means. Some trustees, even those who are not have not resigned or been removed as trustee, if certain actions are brought against them and they're found to be liable, they may be personally liable even as a trustee, and therefore they have to pay out of their personal resources and not necessarily the resources of the trust. But certainly, if you've done something fraudulent or wrong and an action is brought against you and the court's found you to be guilty, even though you're no longer a trust, you're still liable.
What about a case if the other trustees has found that one of the trustees has been in breach? What is the duty of the other trustees in that regard? Are they to just, I mean, I know they can't just remove that trustee. They have to do something else in addition to that?
Indeed. Well, if they found a trustee to be in breach, they have a couple of options. They can ask the trustee to, depending on the nature of the breach, to fix the breach. You follow? So if the trustee stole like $50,000 or fraudulently removed it or acted improperly and said, put the position back to its original position and swear you won't do it again, and everybody goes on business as usual. That is one option.
So
That's
in that case, they wouldn't have to make the beneficiaries aware of it?
They should.
Oh,
If they, whether they do or not is a whole different ballgame in practice, but theoretically they should. And the reason why some trustees will hide something like that is because they know that if they tell the beneficiaries might say what? I don't care if he fixed it. We still want to remove her because they have crooked TIFAs. We still want them removed. And sometimes beneficiaries have relationships, like they know each other, they like each other, they're old buddies or whatever. And so they don't want their person to be, their trustee to be removed because they know them, they like them, there's something them. And so they might hide it from beneficiaries, even though they shouldn't.
so if the beneficiaries are to find out about something like that later down the line,
Yes.
could any steps be taken against the remaining trustees in that regard?
Certainly. If the trustee that committed the breach is still a trustee, the beneficiaries can get together as a group and agree to remove the trustee and bring action against other trustees if they thought that they were in cahoots with that trustee. You follow? If they feel that way, they could do that. Or they can apply to the court and ask the court to come up with a remedy on their behalf, one or the other. If they decide to do it as beneficiaries, they must all agree to do it. You can't have half and half, one wanting, one not wanting, that's not going to work. But they certainly individually or as a group can approach the courts and say, hey, we have evidence that there's been a breach by a trustee and we would like to have that trustee removed and punished in any other way that the law provides. And furthermore, we have information which proves that the other trustees were in collusion in some way, and therefore we'd like some action to be taken against them as well. So that would be a pretty nasty case, but it is possible to do it by all means. And it's important to know that it can be done. Okay? Very strong questions, are very good questions because these are very practical problems that trustees face in modern trusteeships every single day and are constantly under attack as we speak. Okay? Because you don't hear about it doesn't mean it's not happening. Okay? Good points. And notice at the end of that particular last paragraph on that page, it says a trustee's power of discretion may be used in many ways to protect the beneficiary, provided it's a discretionary trust. If it's a non-discretionary trust, doesn't matter if you want to protect the beneficiary from whatever it is, you can't. If your actions in a non-discretionary trust are going to hurt the beneficiary, it doesn't matter. Unless, of course, you put the beneficiary above you in terms of your trusteeship responsibilities. If it's a non-discretionary trust, you must do it. If somebody's going to be hurt, that's somebody else's problem, unfortunately. Now, if you want to take on that problem and violate the terms of the non-discretionary trust, feel free to do that. Just know you're going to come under fire eventually. You shouldn't do it. Now, if you have a discretionary trust, then you can say, you know what, this beneficiary deserves better. And then you can make that decision. That doesn't mean you won't come under fire, but if you can support your decision on the discretionary trust, fine. More than likely, you get away with it as a trustee if it's reasonable and fair. See? And so your discretion to withhold income payments to a beneficiary and use the money for something else, you can make that decision. That beneficiary may find out not be happy. So what the hell? And then he says, well, I didn't pay it to you because you're already a millionaire. I paid it to Tom Jones because he's handicapped and he needed a new chair, or whatever the case might be. And so the rich beneficiary might say, I don't care, dude. I still want my money. I don't care about no beneficiary's chair. Let them crawl on the ground, bastard. I want my money. And the trustee will say, but you're already rich. I made a discretion. And the beneficiary might still sue the trustee. But in a case like that, the courts will probably rule in the case of the trustee and say, dude, what's your problem? You're already a millionaire. The trustee uses discretion. It's a discretionary trust. Case closed. Unless, of course, the courts find out that the trustee, in his discretion, acted fraudulently or unfairly in some way. But if it isn't that, chances are the ruling will be for the trustee. The special reference is made by payments to a creditor. For example, a beneficiary might be entitled to a $50,000 payment. A creditor might find the trustee and say, this dude owed me $300,000, Mr. Trustee. We need to be paid. The trustee in his discretion, instead of sending all or some of the money to the beneficiary, might send it to his creditor, all or some, to pay off his debt. The beneficiary might be pissed and say, how the hell you can pay off my debt? I want my money, and bring action against the trustee. And the trustee will say to the courts, Mr. Judge, Your Honor, this beneficiary owes this creditor $300,000 to which he's paid no money. Creditors approached me, and in my discretion, I made the payment to the creditor to pay off the debt. And more than likely, in a case like that, the court will make a ruling. Good decision. You should pay your bills, Mr. Beneficiary. And furthermore, we rule that all payments go to the creditor until the bill is paid in full. Or we make a ruling if your life is difficult, you don't have any money, that some go to you and the rest go to your creditor until your debt is paid, Mr. Beneficiary. And then they hit the gravel on the table and close the case. Okay? These are how things work in practice. Right? But the important thing is, as trustee, students and advocates and employees, etc., it's important to know that these things are out there, and this is why you must be clear on the differences of the duties and responsibilities of the trustee. They are very different. They have very different and significant requirements. You cannot mix them up. They are not the same. You cannot use one in favor of the other. Duties are duties, powers are powers, and they must be dealt with separately and effectively, according to the trust instrument and according to the law. All right, Shanice, are you there?
Yes, I'm there.
Okay, Shanice, why don't you close our discussion today with trustees' minutes?
Okay. Trustee minutes are often used to document the reasons and discussions made by a trust committee for a professional trustee's discretion in the exercise of its discretionary powers. These minutes are protected from disclosure under the Trustee Act 1998, as they are not considered trust property subject to the beneficiary's right to information and access. With regard to the delegation of trustee powers, the general principle is that a trustee cannot delegate his power as to whom and to what extent trust property may be distributed. However, a trustee may delegate certain duties and tasks in the administration of trusts that may contribute to the exercise of a trustee's powers in the distribution of trust property. A trustee's power or discretion must be a positive mental act and must not result from his omission or inaction. Additionally, trustees are not compelled to give reasons for the decisions, particularly to the beneficiaries. A trustee must take particular care that his powers are exercised honestly. Otherwise, any dishonest or improper exercise of his powers will invalidate it and any distribution made to the beneficiaries depending upon the facts in every case. Equally important is the fact that trustees must exercise their discretion within a reasonable time, which again depends upon the facts of every case. Other circumstances regarding the time and type of the exercise of the power of discretion may determine whether it will be validated or not. The exercise of a trustee's discretion must be done fairly and independently, and a trustee must not be seen as a nominee of the settlor or a puppet on a string. Should the trustee act solely and exclusively by the instructions of the settlor and not act independently, the trust may be declared a sham in many offshore jurisdictions, particularly in the instances where revocable trusts exist and give the settlor very wide powers to control and dictate the trustees and the trust.
Thank you very much, Shanice. Um, I don't know if you have any idea of how much important information you just choked out to us. But even at the end of the discussion of trustee powers, we have all kinds of little powerful expressions that trustees will suffer if they violate any of these powers. And let's just take a moment before we go off to our day to look at a couple of those. First of all, these powers cannot be delegated and they are delegated under the Trustee Act. It is all subject to the trustee being ultimately responsible for their actions. The other thing is trustee minutes are private. The trustee has no obligation in law or otherwise to disclose the details of the minutes, like the reasons why they made the decisions they made under a discretionary trust. Many beneficiaries in the past, and they continue to seek to get the courts to have trustees disclose the contents of their minutes for the most part in the trustee meetings about how to distribute money and make trustee decisions. In a discretionary trust, most of the times the courts rule against beneficiaries. Minutes continue to be proprietary to the trustee, meaning that the trustee is not obligated to disclose that information to beneficiaries. There have been one or two exceptions where the beneficiaries' lawyers were able to show that it is imperative that the minutes be disclosed because it was contingent upon some other activity, which may have included fraud or some other wrongful act by the trustee. If such a position can be to the court clearly and without bias, then it is very likely that in rare cases, the courts might ask or compel the trustee to disclose some or all of the minutes of a particular meeting or meetings. Okay? The other thing that is important here, other than not being compelled to give reasons, is that the trustees must exercise their discretion within a reasonable time. In other words, if you have to take action to invest, to send money to beneficiaries, to sell property, to insure property, and so on, you cannot do it whenever you feel like it. You have to do it within what is deemed to be an appropriate time. If you have to insure property, you have to insure it before the insurance expires and lapses and something happens. You have to send money to a beneficiary. You can't say, I hate that one. I'll send the money late, let them suffer until I send it. Bastard. That's for telling my sister off last week. Whatever the case might be, you cannot do that. You must be uh, unbiased and exercise your discretion properly and reasonably. So if you have to send money, send it in a reasonable time. You have to insure within a reasonable time. If you have to invest in a reasonable time. It is not it's not your money, your assets, your anything. You're there to act in the best interest of the beneficiaries, always, without exception. You're a professional trustee, but all trustees are expected to behave that way. Okay? And then finally, we end our discussion kind of where we began. The exercise of a trustee's discretion must be done, must be done, must be done fairly, and yes, independently. Doesn't matter. We end it as we begin. I don't care what powers and duties you have. Whatever, whether you're exercising powers or duties, you must be fair. You must be impartial. You must be independent. If your boss says they're going to fire you because you came up with a reason to be fair and they did, and they're trying to run some program, then let them try and fire you. But you, as a trustee or working for a trusteeship, have to do the right thing, and that is be fair and be independent. That's the whole point. Okay? Also, the trustee must not be seen to be a nominee or puppet of the settlor. We have some trusteeships that have been established where the settlor controls the trustee. Any trust where the settlor controls the trustee decisions, that trust is a sham trust. Know that now before you go any further in trust. All right. Once the settlor has settled his assets into the trust, the settlor's job is to shut up, get out of it, and the trustee gets to make all the decisions independently as trustee. But we have some trusts in different parts of the world, including the Bahamas, where we have settler trusts, and settlers are still exercising a whole lot of judgment and making decisions for the trust. Now, in modern trusteeships, we have some trusts that we call settler-directed or settler-settled trusts, where the settler is in fact the trustee. And if the settler is the trustee, that's not illegal, but the settler is still, as trustee, bound by the requirements of the trustee. Whether or not a settler could be independent as a trustee is a different issue. Whether or not it's a sham or not will be determined if somebody takes action or the settler trustee is found to be acting improperly. But generally speaking, okay, generally speaking, where the trustee is not independent of the settler, the trust may be declared a sham by the courts if an action is brought by beneficiaries against the trust. Okay? And as we are told, in many offshore jurisdictions like the Bahamas, particularly in instances where there's a revocable trust. What is a revocable trust, anyone? Anybody remembers what a revocable trust is? Some people call it revocable. Same thing. What is it? Nice question to end today. What is a
I think that is when the trust could be like canceled by the settler.
Indeed. If it's revocable, the trust can be canceled by the settler in his discretion at an appointed time based on some contingency, whatever it is, but it can be canceled. Absolutely. And in the modern trust world, under the Trustee Act of the Bahamas, we do have revocable trusts where the settler has wide powers to control and dictate the trustees of the trust. Okay, under that revocable structure, and that should only happen in very rare cases. Under Old English trust laws, that does not happen. And in the UK, in particular, you will probably not find too many revocable trusts. I wouldn't say you wouldn't find any, but you wouldn't find too many where the settler is actually driving the trust and said, don't get me mad, I'll revoke it. Or I'd like to revoke it. I'm only doing this for 3 years. And then after that, I'm canceling this trust. Most trusts are not revocable. Most of them are irrevocable, which means that once they're settled, the settler gets out, shuts up, and be on his or her merry way for the trustee to do his or her work, okay, either as an individual trustee or as a professional trustee. Okay? So there you have it. Suffice it to say, it has been a mouthful on a very precarious journey today on the duties and responsibilities of the trustee. Whatever information you've required up to today, that's fine. It sets the groundwork and the foundation, but certainly these duties and powers are equally, if not more powerfully and more strenuously foundational than perhaps anything you've done so far. And so as students and persons working in the trust world and seeking to work in the trust world, you must make every effort to make sure that these core principles and issues, especially what? Impartiality and fairness. Whatever you do, whatever your duties are, whatever your responsibilities are, Your foundation as a trustee must always be fairness and impartiality. If you violate those principles, you might find yourself in big trouble, big fights with your beneficiaries, with the courts, and God knows who else. All right, you guys have been fantastic today. Thank you very much for being patient while I discovered that our class starts actually at 9 o'clock instead of 9:30. So next week when we meet at 9 o'clock, same place, same time. Please go ahead and do those exercises at the end of those 3 units. When we meet next week, we will certainly go through those so that we can see how you responded. It gives you a chance to go back over the material again. And by the time you've done that, plus our discussions today, hopefully the majority of this stuff will stick in your head forever. Any questions, anyone, before we break? All right, fantastic. Then if you think of anything before class next week, Saturday, feel free to send me an email or send me a text. All right. If there are no other questions, you guys have a great week. Be safe, and I'll see you next week, Saturday at 9 o'clock.
All right, take care.
Good day.
Yeah, have a great week.
Good day.
Good night, good day.
Thank you.
You're quite welcome. Be safe in madness.
All right, take care.